All right, and who's here for Defendant Paul?
Mustafa Derkunt, Your Honor.
Judge, it's Emily Bloom on behalf of Mr. Paul in the original suit, and then Mr. Derkunt is representing Mr. Paul in his cross claims.
All right, thank you. And y'all still expect this will take an hour?
This is Dave Larson for Defendant Uber. I'd expect at least 45 minutes, Your Honor.
Okay.
But we always request an hour just in case.
All right. The next case up is Vega versus 110 East Riverside. Who's here on that?
Yes, good afternoon, Your Honor. John Duff on behalf of the plaintiff.
Stanford Parrish on behalf of Defendant VIP Nightlife.
Scott Weatherford on behalf of Defendant Maxim Inc.
All right, y'all have a motion to compel. Have you had an opportunity to actually speak about it? To see if you can reach any agreements?
Yes, Your Honor. Me and Mr. Weatherford had gone back and forth, several phone calls and several emails. I think there's still a few issues we need to discuss with you, though.
All right. Do y'all want a record?
Yes, please, Your Honor.
All right, and then Zakarius versus Cook.
Good morning, Your Honor. Aaron Hubbard on behalf of the plaintiff.
Gabe Pytel on behalf of defendant.
All right, and y'all have a motion to compel as well. Have y'all spoken?
Extensively, Your Honor. We've got it narrowed down. I think we'll be about 20 minutes.
All right, do you all need a record?
Please, ma'am.
Okay, so we'll take them in the order that I just ran through. So we're going to start with the Pace case. Because the summary judgment is non-evidentiary, there is no record. But so Mr. Larson, well, shall we start with a motion for continuance?
On the Pace case, Your Honor, I'd like to address them at the same time if we could.
All right.
And I would request, I understand in your court it may be not recorded in terms of the record, but I would request that we do that if possible.
Yeah, I've already told Miss Williamson she can go work on some appellate matters she has, so she is not available. All right. Mr. Garcia, do you want to start on the motion for continuance?
Yes, Your Honor. Thank you. I do have a PowerPoint that I'd like to share with, if possible, Your Honor.
All right.
I'll just object to the extent we haven't seen this exhibit before.
There's nothing new on it that I haven't provided.
And just to be clear, Mr. Beck is going to keep track of the time and is putting 30 minutes on the clock for each side.
Thank you, Your Honor. Just to be clear, Your Honor, there is no trial date as of yet, and there is no scheduling order in place in this case. Your Honor, the standard process in these type of Uber cases is the plaintiffs file suit against Uber. Uber then answers. Uber claims an independent contractor status per the TNC code of the occupational code. And plaintiffs, at that point, request proof of Uber's compliance with the TNC statute. And that's what's kind of happened here. In this case, Uber wanted a protected order entered, which it was entered. And in this case, Uber did provide, as standard, the TNC compliance documents to us on or about March 10th, I believe, or 11th. Plaintiff, after that, reviews the documents, and then at that point, plaintiffs decide whether non-suit or keep Uber in the suit based on the documents provided. That's a diligent process, Your Honor, but it doesn't happen very quickly. But the issue in this case is this is not a standard Uber case. In fact, I think it may be a first for Uber, according to defense counsel, that the driver, Mr. Paul, has sued Uber as a cross-claimant, claiming some sort of employment relationship with Uber. And he filed that pro se on or about March 12th, Your Honor, which was right on the statute, the limitations date. So that kind of threw a wrench in everything for a little bit because we weren't anticipating that. This new claim of some sort of employment relationship by the driver against Uber. And understandably, that caused some concern for Mrs. Pace as to being cautionary about dismissing Uber at this time, even though we do have some documents alleging they had complied with the statute that labels them as independent, labels the driver as an independent contractor. But since Mr. Paul raised this issue himself as a driver, we had to step back a little bit and make sure we're doing the right thing based on this new cross claim against Uber, which is not standard in these type of cases. And even if Uber admits that in their answer, Your Honor, that there is an issue, okay, whether it's a mischaracterization on my part or not, regarding Mr. Paul's pleadings. Their pleadings are not a mischaracterization. That they say cross claimant alleges there may have been some sort of employment relationship with defendant. So again, that caused concern for us as far as dismissing Uber based on documents they provided detailing the compliance with the statute. Now, I'm not going to labor the court with this timeline, but just notice that if you can judge that this case has not been on your docket very long, or on the docket very long. We're talking about 5 months total. Mr. Paul's attorney, Mr. Durkant, just 2 weeks ago filed a notice of appearance on his behalf. That was something we expected, and we were willing to wait for that. I would also, with his defense counsel, to wait for that to hold off on noticing for his deposition and get into the business of discovery until all parties were represented. Let's see here. So, in response to Uber's MSJ, we did file a motion for continuance to be granted. Like I said, we don't even have a scheduling order in place, Your Honor, in this case. And why does plaintiff need more time for discovery? We need adequate discovery has not been conducted to verify Mr. Paul's alleged employment status against Uber. He filed his petition on March 13th. That's about 2 months ago, and that was pro se. Again, we waited. We understood that somebody's going to be filing a notice of appearance on his behalf. That happened just on May 13, 2025, 2 weeks ago. And it's my obligation, Your Honor, to make sure to protect Mr. Pace's, my client's rights and claims, and make sure Mr. Paul does not have a legitimate claim or issue regarding his appointment status with Uber, regardless of whether Uber has provided documents that show that they complied with the statute. This looks like it might be in a type of case that's first impression of this type of matter. But there's no doubt that there's an issue out there, and my client cannot dismiss Uber until we verify his claims, and we need to do that through the discovery. And most importantly, we need to verify this because the statute of limitations has run. So Ms. Pace my client needs to make sure Mr. Paul has no evidence or valid argument before dismissing Uber. What type of discovery do we need? I just want to make perfectly clear, we don't need anything from Uber. We're not going to ask for Uber's any corporate rep depositions or I've asked them to provide any policies or procedures. We just need Mr. Paul's discovery, whether through written discovery or deposition. We're not here to harass or make Uber incur any additional unnecessary costs by any means, Your Honor. We just need that to verify his claims. What entitles plaintiff to adequate time for discovery? Well, Texas Rules of Procedure 166, Your Honor, says party cannot move for summary judgment or may move after an adequate time for discovery. We have not had an adequate time for discovery in this case. It's still in its infancy, as you can tell by the timeline and the appearance of parties just got completed 2 weeks ago. And the test for the motion for continuance and adequacy of time for discovery is the nature of the case. This case went from typical to complex once Mr. Paul filed suit against Uber, his own as a driver, within in the context of cross claims, and of course Uber counsel I just stated admits this is a first. Okay, and the nature of the evidence necessary to controvert the no evidence motion, we need the written discovery from Mr. Paul. That's it. And even as a cross claimant, I'm not even trying to get his deposition or any discovery from him as a defendant in this case. We think we got a straightforward liability claim against Mr. Paul as a defendant. And the discovery cannot be procured from anyone else. The length of time in this case, Uber filed their MSJ on April 14th, Your Honor, of this year, less than 4 months after we filed our petition. The amount of time that the no evidence motion was on file, it's been on file just a little over a month because we've been trying. Once they file this MSJ, we put a halt to everything. And once this MSJ is ruled on, we are all ready. All parties are available now to really get into discovery, including Mr. Paul's deposition. Matter of fact, my client's deposition was just noticed today for June 10th this year. Again, we have no scheduling order in place, so there are no restrictions on timelines right now. Little to no discovery has been done. Initial disclosures have been served, but Mr. Paul, as a cross-claimant, has not served his yet. And again, there's no scheduling order in place. And for these reasons, Judge, we believe that a continuance should be granted in this matter. Thank you.
All right, thank you. So, Mr. Larson.
And Mr. Garcia, if you could just take down the slideshow.
I'm trying. Hold on. Let's see here. Let me end the slideshow. How's that?
I can see your email now.
Okay, sorry. I'm trying to figure out how to.
There ought to be a stop sharing button.
I got it. Thank you, Your Honor. Got it.
Your Honor, and just to be clear, do you want me to address just the points about the continuance first?
Yeah, let's start with that.
Sure. As it relates to the continuance, the argument that you saw by counsel, and we're not disputing there's no trial set yet, and that's certainly not the standard in determining whether there's been time for adequate discovery done. And there really wasn't anything addressed there about the fact that this is also a traditional motion for summary judgment, which really has no limitations. Texas law is really clear on this. I think counsel understands how clear it is by the willingness to non-suit, at least initially. But really the argument about the continuance is that they haven't been able to do discovery solely as it relates to this cross claim. And everything is about the cross claim and what they say he alleges in there. It's really not clear what he's alleging, and taking language from the special exceptions, which are setting forth how vague and conclusory those allegations are, really doesn't do anything in terms of creating an issue of a genuine issue of material fact. As far as the motion being premature, again, the cross claim does not change the landscape of the case as plaintiff alleges. You saw the timeline. The original petition filed in December 2024. that includes language that's much clearer about there being an employment relationship between Mr. Paul and Uber. That's specifically what plaintiff's claim has been since the lawsuit originated. Now, plaintiff, despite all that, was willing to non-suit Uber because plaintiff understands that the law is clear on that and that it's wrong. So, Mr. Paul's cross-claim, with the vague nature of it, doesn't do anything to raise an issue of a genuine issue of material fact, and doesn't affect the timeline of the case or justify a continuance. There has been counsel in the case for Mr. Paul since the end of January 2025. Hasn't been any effort to depose him or, get his take on any of this. It's not that the cross claim all of a sudden gave them notice of there being some kind of issue about employment. Again, it's been alleged since the beginning of the case, and just haven't done anything to find out more about what Mr. Paul's take on it was, because whatever Mr. Paul says about his relationship with Uber it's just simply not going to change very clear Texas law that says that Mr. Paul is an independent contractor and not an employee for all purposes. And that's the occupations code 2402-114. Texas law is also really clear, if that wasn't already clear enough, that
244.114.
Correct, Your Honor. 2402.114 is the driver's status as independent contractor statute. And beyond that, Your Honor, the insurance code, I could find the exact section, but it's 1954, I believe, .101. It says that TNC drivers like Mr. Paul here, which plaintiff doesn't dispute, he is a TNC driver, that a TNC like Uber does not manage, direct, or control TNC drivers like Mr. Paul. So between the insurance code, the occupations code, and the subsequent case law that's been issued out of Dallas and El Paso, in the form of the Fryer and the Acosta Molina cases, that was just very recent, in terms of the latter. Fryer's been out for a while. This is all just very clear, and plaintiff understands that. That's, so as far as the need for a continuance, it's not justified, and plaintiff hasn't said anything forth to justify why we can't deal with these issues as a matter of law.
All right, Mr. Durkhunt.
And I don't believe Mr. Durkhunt's filed anything as it relates to this motion.
Mr. Durkhunt, would you please unmute yourself and turn on your video camera? Are you here, sir?
I heard him earlier, Your Honor. I'm not sure.
I did as well. All right. Well, then let's go back.
Yes.
Mr. Durkhunt.
Yes, Your Honor.
What is the basis of your client's claim against Uber?
Your Honor, based on Uber's implied, he had an implied agreement with Uber, and he purchased a $70,000 vehicle to do Uber, and for no reason he was put off the system, and he was stuck with the payments, and he's unable to make a living, Your Honor. And we believe that there was a common law fraud here. Whenever a customer makes a complaint, like in this lawsuit, Uber does not feel the need to investigate and just puts people off the system, despite the fact that he presented a video that shows that he's totally innocent, that it was some third party who made threats with a gun, and
I'm
that
sorry.
the driver at
The third
Grizzly-
party did what?
Excuse me?
I didn't understand what you just said. The third party that did what?
Displayed a gun and threatened the driver. And although the driver did nothing wrong, Your Honor. And we believe that Uber should not have put third-party claimant of the system.
All right. What does that have to do with the accident between Miss Pace and Mr. Paul?
Well, he was put off the system because of this incident, Your Honor, not because of something else.
So how does that affect the claim that he was not an employee of Uber, but instead was an independent contractor?
Well, Your Honor, he was as an independent contractor. He was working for Uber.
Yeah, I don't think anybody disagrees with that statement.
Right. One moment, Your Honor.
I'm sorry?
I did not get your question, Your Honor.
Yeah. I wondered how it is that any of this matters to the claim about whether he's an employee rather than an independent contractor.
To us, it doesn't matter, Your Honor. Either way, he was working for Uber.
All right. Ms. Bloom, do you have a position on this?
No, Your Honor, we only represent Mr. Paul as a defendant.
And do you have a position on Uber's motion for summary judgment?
No, Your Honor.
All right. Mr. Garcia, let me hear your response to, why, I want to hear Mr. Garcia's response to Mr. Larson.
And Your Honor, I think I only addressed the motion for continuance. I mean, I don't think I would have too much more, but if I could just address the motion very quickly to the extent I didn't already hit on, like, at least the law parts.
Well, right now I'm focused on the motion for continuance.
Okay. Got you. I'm sorry, I misunderstood, Your Honor.
No problem.
Your Honor, you want me to respond to Mr. Larson's argument or to what Mr. Durkin?
Both.
Both, okay. Well, as Mr. Durkin, I'm still not clear, Your Honor, what type of employment relationship Mr. Paul is contending to have. He says one way or the other. Well, we still don't know which way it is. And I don't think we can get that until we depose Mr. Paul. I don't think questioning Mr. Durkin's answers to your questions, Your Honor, were very clear and concise. As opposed to some specific answers or...
Let me just ask you this.
Yes, ma'am.
How quickly do you think you could get the discovery that you need to be able to determine whether in fact you can drop Uber?
As soon as Mr. Durkant makes Mr. Paul available for a deposition with the next month, Your Honor.
All right. Well, then here's what I'm thinking. I'm thinking that I'm willing to continue this hearing until the week of June 30th, by which time you need to have gotten the deposition or whatever else you're trying to get. And you will be able to determine whether you in fact have a claim that would require you to not drop Uber.
Thank you, Your Honor.
All right.
We
And
do
I'll retain the case since I have begun looking at the file. So you won't have to start over with somebody else. And so you're suggesting that all you really need to do is take Mr. Paul's deposition?
That is it, Your Honor. I just need to
All right.
depose him and figure out whether he's got legitimate claims or not, and whether he's
All
got,
right.
yeah.
So, Mr. Durkant, is there any reason why your client should not be able to give his deposition in the next 2 or 3 weeks?
There's no reason, Your Honor. It's quite possible to get the deposition.
All right. Well, let's do that, and we're gonna basically just suspend the hearing, and we will continue it the week of June 30th. So I'm going to ask you to talk among yourselves and see what day that week. The 4th of July is Friday, so it'll need to be one day, Monday through Thursday. And it looks like to me I only have morning hearings on Thursday set so far. So other than Thursday morning, you ought to have a wide open, and what you'll need to do is contact Miss Fatima, who sent you an email about setting up this Zoom, and we'll just continue the hearing at that time. All right.
Understood, Your Honor.
All right. I'll see y'all then.
Thank you.
Y'all are excused.
Yeah.
All right. So I'm looking for the motion to compel was filed on April 24th. Is that right?
That's, I think I have the 23rd or 24th. Yes, Your Honor.
And is there a response?
Yes, Your Honor, there's a response that should be uploaded in the box for you
What day was it filed?
this
Today.
morning.
Definitely has not made it into the electronic file. So let me look in box. All right. The response was filed by whom?
Your Honor, there was a response that was filed this morning. It should be in box under Defendant Biglari Holdings and Maxim.
Got it. All right. So, Mr. Duff, it's your motion to compel.
Yes, Your Honor.
You may proceed.
Thank you. Your Honor, I'd like to give you a few facts to put this motion into context.
Yes.
Yes, Your Honor. So my client, he attended a Maxim Formula One party on October 21st, 2023. That's when the big race was coming through Austin. There's a lot of sponsors and a lot of big events going on during that weekend. Maxim was essentially the host and sponsor of this Maxim party, as it was called, at this nightclub called Superstition in Austin, Texas. My client was also brought on to be one of the sponsors since he owned a car dealership in the area. He was sitting at a booth right next to a DJ by the name of Diplo. During this event, it was found out and discovered that some entity had moved the barrier between the general admission and the VIP section. This caused a lot of the general admission ticket holders to flood the VIP section. Well, my client was at a VIP table right next to the DJ, and his booth got ran over by some general admission ticket holders. 3 men pretty much accosted him, stole his very expensive watch that he owned, and tried to leave. And so my client kind of lunged after them, trying to get his watch back. Security guards grab him, throw him to the ground, throw him outside of the nightclub. So we sued Maxim because they essentially were the hosts of this party. We sued the bar, we sued the security company, and we sued the promoter of this event. Throughout the course of this case, Maxim and Biglari answered the lawsuit very quickly. We were having difficulty getting the security company as well as the bar to answer our lawsuit. We had to file motions for substituted service, get those ruled on, as well as the promoter. The promoter was essentially dodging service out in California. We had to get a motion for substituted service on file, and eventually got to a point where we had a default set up against all 3 of those entities. The promoter just answered about 2 weeks ago, and the promoter being VIP Nightlife LLC. And so throughout this time, I was waiting to start engaging in discovery with these other defendants, because I assumed that I've had a lot of these cases where, people dodge service and then we have a default set up, and then sure enough, someone answers right on the eve of the default judgment, as VIP Nightlife did in this case. Well, 2 of the defendants did not answer or show up for the default hearing, so there was a default entered last week against 2 entities. But I haven't even been able to engage in any discovery with VIP Nightlife yet, just because they recently answered. And so throughout this time, I've been talking with Mr. Weatherford, who is attorney for Maxim and Biglari Holdings. And he puts in his response to our motion to compel that I filed my motion to compel based off of his representation that they're going to be filing a motion for summary judgment. That's not necessarily true, Your Honor. I was trying to get some discovery going with all these parties, but was unable to, except for with Maxim. I sent discovery in early January. There was very insufficient discovery responses or answers or even production given with those. So I sent a discovery deficiency letter to Mr. Weatherford in March, well before the motion for summary judgment was filed or set for a hearing.
Would you mind slowing down a bit for me? You're kind of speeding through this, and I'm trying to make a record for you.
Sorry about that. I will slow down. And so, Your Honor, Maxim did file a motion for summary judgment. We did set this hearing, motion compelled for a hearing, because there are several items in the discovery and the amended discovery responses from Maxim that we just need answers to or objections ruled upon. And Your Honor, I can go through some of those with you. It is interrogatories 2, 5, and 7. Request for production 3, 4, 6, 7, 16, and 21. And also 19 and 23 for request for production. The ones I named previously, or numbered previously, Maxim and Mr. Weatherford are saying that there are documents that they have in their possession. They are just refusing to produce them based on either attorney-client and or work product privileges. So at this point, we have a motion for summary judgment set in 2 days from now on Maxim's motion for summary judgment, and I am being told that they have documents or answers responsive to my questions. I just don't have those answers, and more likely than not, I'm probably going to need those for a response to the motion for summary judgment. Of course, we do have a motion for continuance on file for the motion for summary judgment, but that's why we're here today, to try and see what else Maxim has that has not been produced. Initially, we weren't produced anything. Then we were given about 40 photographs and a joint venture agreement between the promoter, VIP Nightlife, and Maxim. And then Friday afternoon, we were given about 100 photos and 4 videos, but no emails, no other documents about this event. And Your Honor, this is even more of an issue because the VIP Nightlife, I guess, in-house counsel in California, I had been communicating with him since January of this year. He said initially he was trying to get the case resolved without having to answer a lawsuit. I said, we're not going to do that. And so he tells me that there was a VP of events and experience of Maxim. So Maxim's VP of events and experience at the nightclub that night, and was the one helping set up this entire event on behalf of Maxim and with the promoter. And so initially, I didn't know what Maxim's involvement was. I thought it might just be their name on the wall and names on bottles and names on tables. But it seems like, and without being able to do discovery and without being able to talk with VIP yet, because their initial disclosures aren't due until late June, it appears that there is some involvement by Maxim more than maybe even Mr. Weatherford knows, or there's boots on the ground essentially for Maxim, and I'm trying to get to the bottom of that prior to this motion for summary judgment, of course. But with what I've been produced and the answers I've been given, it's wholly insufficient under Texas law. And Your Honor, we would respectfully request rulings on those objections to the numbers I have previously given and full and adequate responses to those discovery requests.
All right. Mr. Weatherford?
Thank you, Your Honor. Scott Weatherford at Jackson Walker on behalf of the defendant, Maxim Inc., and the respondent. Your Honor, this motion to compel, in my mind, is not much more than an attempt to avoid summary judgment in this case. I think it's clear from the procedural background that I'll lay out for the court in a minute that demonstrates that these discovery issues were brought up directly in response to our filing of the motion for summary judgment. But even more than that, it's clear from the fact that we've done everything we can to get plaintiff the information he claims he needs. We made supplemental productions, we withdrew objections, we amended our answers, and we repeatedly asked, what else is there? What else are you claiming is at issue? The list that Mr. Duff rattled off a few minutes ago was the first time in multiple conversations that I've ever heard what specific requests they are actually taking issue with. If you look at their motion to compel, there are not even any requests specifically mentioned. So we never got an answer to that last question until today, and we couldn't really tell from plaintiff's motion either, which just generally takes issue with all of the responses as a whole. So we're asking the court to deny the motion to compel because it is improper, it's moot. We've addressed largely of the issues that are outstanding, and the objections that we have asserted have a valid basis. So, Your Honor, this case has been pending for nearly a year. No depositions have been taken. The only discovery that's been served by the plaintiff or the ones that are at issue in this motion, which we first answered back at the very beginning of this year. In March, we informed the plaintiff that we intended to move for summary judgment because Maxim is simply not involved with the operational and management control of the event. They effectively licensed the use of their name so that the party was called the Maxim event, but we did not have any employees present at the event. We did not have any operational control at that event. So that's what our motion for summary judgment is based on, and that's what I told Mr. Duff we'd be filing it on. The plaintiff's response to our outreach when we told them we wanted to file this motion and set it for hearing was that we were told that they were unavailable for a hearing that month. And then secondly, immediately after we notified them of our intent to seek summary judgment, plaintiff took issue with our discovery responses, I think the same day. And so after that, we continued to confer about available dates for a hearing.
What's the date of your motion for summary judgment?
The motion for summary judgment was filed, I think, at the beginning of this month.
May 8th, Your Honor.
Except for May 8th. There you go. But what we did is we didn't file it until we had a hearing date. So I told Mr. Duff back in March that we wanted to file this. This is what it's going to be. Please let us know when you're available. And so that's when we started having these discussions. So when the plaintiff takes issue with our discovery, we continue to confer about available dates. We were told again that we couldn't do it the month of April due to an existing trial setting that plaintiff's counsel had. We conferred again. We were told that May 15th would work. When we sought to confirm that date, we were told that May 15th is now gone. And the very next day, plaintiff filed this motion to compel and set it for virtual hearing at a date and time of its own choosing. And you can imagine our surprise about this, Your Honor, because we had attempted for 6 weeks to schedule a mutually agreeable date to argue the motion for summary judgment. And then we get hit with a motion to compel the day after I sent an email saying, by the way, I'm working on a response to your discovery letter, still trying to get this motion set. Nevertheless, we looked at the motion. We worked to try to confer on the issues that plaintiff had in our discovery responses. We served amended responses and objections, which are attached to our response. We produced additional documents. In email correspondence, when I sent the amended responses, I requested, if there are any specific requests that you still think are deficient, let me know. Happy to talk with you. Please identify those and let's talk. In response, the email that I got that's also attached to our response basically said, hey, I think there are more photos and videos out there. One of the photos you produced shows a videographer, one shows a cameraman. Check and see what you got. So I spoke with Mr. Duff, figured out what exactly he was looking for, and we went and tried to gain access to those photos and videos, and we produced them. And then again, my question is, what else is there? What other claimed deficiencies do you have with our discovery? I didn't get a response. And I never, as I said earlier, got a list of the specific items that are at issue still today. So the motion itself, Your Honor, is deficient in several respects. I really don't think there's a dispute here. I think this is mostly just an effort to avoid summary judgment. But even so, I haven't seen any argument regarding any of the requests that were rattled off in the opening. I can try to go through these. I tried to write them down as fast as I can and explain our objections if that would be helpful. But I can highlight a few for the court just to show an example of what we did object to. The first would be RFP number. Well, John, do you have? Can you tell me that list that you read off again?
Yeah, absolutely. On your responses, it's interrogatories first, so that's kind of how the order I have them in, but it's interrogatory 2, 5, and 7. And then request for production is 3, 4, 6, 7, 16, 21. Those are on the basis of withholding documents that I don't know what is being withheld. And then the other 2 were about 19 and 23 about previous incidents, lawsuits, claims against Maxim for similar events.
So, Your Honor, on the interrogatories, number 2 asks us to identify a person who examined or investigated plaintiff's claim, talking about insurance adjusters, things like that. There's no insurance at issue in this case. And we said that in our response, that defendant did not conduct any pre-suit investigation or initiate any pre-suit investigation. So there was no one at Maxim who examined or investigated plaintiff's claim until they got notice that there was a threatened litigation. And then, of course, there's work product privileges that come into play when counsel is hired and communications take place and investigations are done. So I feel like we fully answered number 2.
I responded to that one. If we want to take these one by one, it's however the court prefers. And I can also share it with the court as well.
Yeah, go ahead.
You want me to share my screen, Your Honor?
Sure.
And just so you all have an idea where we are, each side has about 7 minutes left.
Your Honor, so this interrogator number 2 says nothing about insurance. It just says agents, consultants, independent adjuster offices that examine or investigated plaintiff's claims. We're just trying to find out who these people are. Sound like Mr. Weatherford said that there wasn't anyone, and then it says their defendants withholding further information responsive to interrogatory on the basis of the attorney-client or work product privileges. That's most of the issues I have with their responses has that same language in there. So I don't know what is being withheld, what they have that is responsive to this. I asked Mr. Weatherford for a privilege log on Thursday. He said he doesn't need to produce one until he identifies what's exempt from it. That's my understanding of what Mr. Weatherford said, and he can correct me if I'm wrong. But that's essentially the issues we have with their discovery responses, that language that they have.
Your Honor, my position is a little bit different than that. As the court knows, first of all, I don't know that a privilege log has actually been requested, but even if it has, there is an exemption for any communications or work product that occurs after the point the party anticipates litigation and engages a lawyer. So what I was saying earlier is that until this claim was ripe and until we got notice that there was a potential claim, that was obviously the point that my client anticipated litigation. So there was no pre-suit or pre-claim investigation. There was no pre-suit or pre-claim independent adjuster analysis or agents or consultants hired or anything like that. So I'm required under the rules to include a withholding statement, even if it's not required to be disclosed under Rule 193.3, and that's what we've done here.
Well, so are you saying there is material that's being withheld or there is not material being withheld?
For this specific interrogatory, I mean, it probably doesn't make a difference. I think the person would be my client representative and probably myself as the attorney of record, but communications between me and my client are certainly being withheld, Your Honor, if that's the question.
Well, so I'm just looking at 193.3 and it says a party who claims material or information responsive to written discovery is privileged may withhold the privileged material or information from the response, but must state in the response that information has been withheld and the privilege or privileges asserted. And so I see that you're saying you're withholding further information on the basis of attorney-client or work product privilege. But he's saying that after he got that, you're supposed to tell him under 193.3b a description of what's being withheld. So I think that's what he's asking for when asking for you for a privilege log.
Right, Your Honor. And what I was attempting to point the court to, I think I may have miscited the actual rule, but it's 193.3C. which talks about the exemption to the requirements to produce a log under 193.3A and B, which says that without complying with those paragraphs, a party may withhold privileged communications that are between a lawyer and a lawyer's representative, or a privileged document of a lawyer or lawyer's representative. So the documents being withheld with respect to this request are communications with respect between me and my client, and documents that my firm has prepared in terms of its investigation of this particular claim.
All right. And why isn't that good enough, Mr. Duff?
Well, Your Honor, I mean, there's several of these answers that they've given to different interrogatories. It just seems like there's a lot more information that they have or collected. You know, I don't know if it's through work product or if it's stuff that should have been disclosed in, you know, the required disclosures. I don't really know what the universe is that they have. And so it's kind of hard to say, okay, hey, I'm just going to take this, you know, attorney-client or work product privileges and just take it at face value, especially when they're telling me they have no involvement in this event. And then I'm told that Gerald Pacheco, Maxim's VP of Events and Experience, was actually at this event. And I didn't see that name in any disclosure response, any interrogatory response, anything like that. And I'm told that from another attorney representing VIP Nightlife LLC. And so that's what my real concern is here, is that there is information being withheld on some privilege assertion, and I don't really know what they have or what's privileged or what's not privileged. And so, you know, if we can get some information under 193.3B, that might help clear up a lot of these issues that I'm having with what's being withheld.
So what I understand Mr. Weatherford is saying is that under 193.3C, a party may withhold a privileged communication without complying with paragraphs A or B. And that if what he has is his conversations with his client or client rep after his client started consulting with him about this litigation, then he doesn't need to either describe it or produce it.
I understand that part, Your Honor, but it's not in the actual discovery or responses. If it's, you know, defendants withholding information that was, you know, a privileged communication to or from lawyer representatives, and actually listed all of that, so I could know that that's the privileged information being withheld. But this is just saying they're withholding privileged information on attorney-client and work product privilege. I don't think it meets the level to get the exemption to be applied to Maxim in this case. Just, I mean, if that was the case, any person or party could just say, yep, I'm withholding responsive information based on attorney-client and work product privileges, and just do that on every single response to every discovery question.
Your Honor, that's exactly what the rule says. Rule 193.3A says you've got to do three things. You've got to state that information or material responsive to the request is being withheld. You've got to identify the request to which the information or material relates, which we've done in each different response. And you've got to allege the privilege or privileges asserted.
So I think what he's talking about is work product under 192.5, that there's some kinds of work product that is protected and some that is not, right?
Correct.
So I think he is concerned about whether you're protecting some kinds of work product that aren't protected. Am I following you, Mr. Duff?
Yes, Your Honor, thank you.
I guess that's the question. Are you withholding any of the work product that is an exception to 192.5?
Let me just read 192.5.
Part C is the exceptions.
I'll just say this. I am not aware of any work product that is not core attorney work product. Again, we did not know of this suit until we got, I think, a demand letter, or maybe even the lawsuit was filed, upon which counsel was retained. And I have not seen anything that would indicate any sort of internal investigation was done prior to engaging counsel that's being withheld at this point.
So you're telling us, Mr. Weatherford, that you've turned over everything that is not core work product.
Correct. I'm not, well, correct. I'm not aware of anything that is being withheld that is not core work product by attorneys.
All right. I don't know how much further I can go with this inquiry, Mr. Duff, or I should say you can go. Let's go ahead and take the document off the screen. Thanks. So what is it that you're wanting beyond a statement like the one Mr. Weatherford just made?
Well, on that interrogatory number 7, I was just showing you, we're asking about defenses raised by Maxim, if they have, responses to that. I said, as to each defense raised by you by way of an answer, state separately for each such defense all facts which support the defense, list all witnesses which support each defense, and identify all documents related to each defense. And they say they're withholding documents. So like that, that's why it just doesn't really make sense where they can put all these affirmative defenses in an answer and then say they're withholding documents about those defenses. And then, I know we were running short on time, but the last two were just other lawsuits, claims against Maxim for similar events that have happened in the past, because Maxim hosts or is the sponsor of many of these parties every year. They have a lot of advertisements in New York, Florida, California, Vegas, all over. And I figured there might be some other claims out there, and I inquired about them, and they say that they're withholding documents or not going to give them to us, period.
Well, so let me say a couple of things. Under 193.4C, they don't get to use anything they're withholding now. They don't get to use it later. So to the extent that your concern is that they're withholding something for a defense, they can't do that and then use it later.
I'm just concerned about the summary judgment. If the continuance is not granted and there's documents that have been withheld, I'll just never know.
All right, Mr. Weatherford.
Briefly, Your Honor, I'll address the two that were just brought up. I think interrogatory number 5, our issue with this is simply its scope. I mean, if you read this, what it is asking us to do is, for each denial of a request for admission, the plaintiff wants to know the complete description of all facts which support that denial, all witnesses that support that denial, and all documents relied upon that you relied upon to make that denial. And when you count up all of the denials in the request for admission, which I think there are at least 29 of them, and you take those 3 categories of information, that's over 90 separate and discrete requests. And these are discrete subparts that are not just one category of information in one interrogatory, although it's presented as one interrogatory. So our objection to that was, first, it requires us to marshal all of our evidence, which is expressly disallowed under the rules for interrogatories. And secondly, it contains multiple discrete subparts, which, taken as a whole, vastly exceeds the number of interrogatories that a party can serve. On the RFPs dealing with other lawsuits, Your Honor, a plaintiff is not entitled to just get unfettered discovery about other claims that deal with personal injuries. You know, if there's a specific aspect of the suit that's at issue that may be that another lawsuit might be relevant to, perhaps arguably that might be something that could be discoverable, but that's not what's being asked here. What's being asked in these specific requests in 19 and 23 is basically all documents related to any incidents, near misses, injuries, deaths relating to any individuals who have been injured for the last 10 years, Your Honor. I mean, that is just I don't even know where to begin to try to figure that out. And the same thing with 23, any and all documents in which you've been sued. Well, this information is obtainable from another source. First of all, they can search public records to the extent there are other lawsuits against Maxim. But again, they're not entitled to go look at any lawsuit in which Maxim's been a party, regardless of the subject matter and if it relates to what's at issue here.
Everyone, I'm sorry to interrupt, but we're out of time.
On both sides?
Yes, Judge.
Okay.
Your Honor, number 23 was just going 5 years back from the date of incident. Any claims from similar events?
But number 19 was 10 years.
What is the basis of the motion for summary judgment that's being heard in 2 days?
Your Honor, the basis for summary judgment is it's a traditional motion for summary judgment. The argument is that Maxim, to prevail on the type of claims that the plaintiff has asserted in this lawsuit, which are personal injury claims at a nightclub, there has to be a duty owed, right? And in order to, in this type of setting, for a party to show that, you've got to show that my client has some sort of ability to control what happened at this nightclub, or actually did exercise control at this nightclub. And our position, as I've told plaintiff all along in this case, has been we simply didn't have that. We entered into an agreement which has been produced to the plaintiff that delegated all operational control to other parties, and we had no oversight or management. We couldn't control the barrier that Mr. Duff says was removed. We had no one there to do that. So it's a traditional motion in that respect, Your Honor.
Your Honor, if I may briefly just respond to that.
All right.
I was told on April 7th by Ryan Powers, who is the California attorney for VIP Nightlife LLC, that Maxim's VP of Events and Experience, Gerald Pacheco, was there and was running the entire event. That was Mr. Pacheco, or Mr. Powers' words about Mr. Pacheco, that he was running the entire event. And I was told that a month and a half ago, and that name is nowhere to be found in one document produced by Maxim in this case. So no inquiry was even made, in my opinion, about what his VP of Events and Experience was there, what he was doing. And essentially Maxim's either saying they didn't know, or they're not producing information that he was there.
And I've told Mr. Duff this. Mr. Pacheco is not our employee. He is an independent contractor who basically has one job. He licenses our name for these parties. And that's what he did in this case. I'm not surprised that another co-defendant's lawyer is claiming in a Rule 408 settlement communication, trying to shift blame away. But that's the fact of the matter.
All right. Why isn't that sufficient to know?
Why is that for me, Your Honor?
Yes.
Why is it sufficient to know what Mr. Pacheco? Well, so if I'm understanding you correctly, Your Honor, if that's what Mr. Weatherford is saying, that this guy just promotes Maxim and signs deals on behalf of Maxim and
Isn't an employee of Maxim.
He's not an employee, but he's an independent contractor, and he's holding himself out to be the VP of events and experience, and he's been that for 6 years, according to his LinkedIn. That's attached to my summary judgment response. If he's holding himself out to be the AVP of Maxim, and he's actually boots on the ground running the entire event on behalf of Maxim, Maxim will have liability in this case. It's apparent authority, Your Honor. He's acting, saying, "Hey, I'm Maxim's VP. Let's do this. Let's do this. I run these parties. I run these events all the time. We need to get more people in here." So
Mr. Duff.
Slow down, Mr. Duff, please.
Sorry.
So doesn't apparent authority require some action on behalf of Maxim? In other words, it's not enough that somebody says I'm acting on behalf of Maxim. So are you suggesting that's the information that you need?
I would like to take his deposition. I would like to find out more information about his relationship with Maxim. If it is really independent contractor, if he's paid salary or just paid bonuses per party.
That taking his deposition isn't part of this motion to compel.
I understand, Ron.
That's part of what you're going to argue in a few days about whether the motion for summary judgment should be postponed. I get that. What is it in the discovery responses that you think is being withheld that would help you with this particular person?
Well, Your Honor, I had to find his name out from another entity. And so if Maxim's not giving me his name, even though he's their VP of events and experience, that's what's made me very cautious about what else has not been given to me. If there's other agreements that Mr. Pacheco has signed on behalf of Maxim, other communications from Mr. Pacheco to anyone involved in this suit, or even to my client, that's something I would expect Maxim to have, since he is holding himself out to be their employee, and Maxim has not seemed to correct him on that ever.
All right. Let me just say a couple things. One is you've got 11 discovery responses that you want to compel, and you set this hearing for 30 minutes. And we've already exceeded the 30 minutes. And Mr. Weatherford is saying, you didn't even tell me in your motion to compel which items you wanted to discuss. And I do think if there are particular items that you want to discuss, you do need to lay those out in your response. I don't have in this hearing, I haven't heard the specifics on everything that you're asking for that you didn't receive, but I would suggest in the future you're going to need to ask for more time than 30 minutes total, because 30 minutes total is 15 minutes per side. I have not heard of anything specific that is a deficiency in the responses, other than I think there's more there. I do agree with Mr. Weatherford's comments that he's not required to marshal all the evidence, and he's not required to give extensive responses on, for example, interrogatory number 5, for each denial, a complete description of the facts on which the denials were based and all of the witnesses and what they would have said. That said, I don't have anything in particular in this motion to compel that I have enough information on to compel at this point. So I'm going to deny the motion to compel without prejudice for you to file a more specific motion to compel and seek longer time to argue all of it. But at this point, I don't have enough information to grant your motion to compel. This is without prejudice to your seeking your motion for continuance, because I'm not ruling on that. All right.
Yes. Sounds good.
All right.
Thank you for your
Thank
time,
you
Your
all.
Honor.
You guys, that would be excused.
Yes.
Your Honor, and while you're pulling that up, I do just want to let you know, we do have a partial agreement on a majority of the motion that I'll read into the record once you have everything ready. And I believe we're down to about 9 items that we'll actually need decisions on.
Right. So this is your motion to compel that was filed on May 5th?
Correct, Your Honor.
Okay. All right. Why don't you go ahead and read your agreement into the record with the understanding that you can't read too fast.
Certainly, and I will
Order.
do my best.
All right.
We have agreed that Defendant Costco Wholesale Corporation will serve a privilege log pursuant to Texas Rules Civil Procedure 193.3 on or before June 11th. Also on or before June 11th, it will withdraw its objections to interrogatories numbers 1, 2, 4, 5, and 10, and request for production number 8, 10, 11, 12, 13, 15, 16, 17, 18, 19, 22, 24, 33, 34, 35, 43, and 44. And that any additional information responsive to those interrogatories and requests for production will be either in an amended response to interrogatories or produced on or before June 11th of 2025. And I will defer to Mr. Pytel if that accurately reflects our agreement.
It does, Your Honor. I think the only concern would be the June 11th date, just because I did explain to Mr. Hubbard that basically these responses go up the chain. So it's not so much that I have the freedom to just, supplement. I need to get these approved by my client. So I don't know, Mr. Hubbard, you want another week, or we could stick to June 11th. I know we talked about June 11th, but however you want to address it. I think most of the I guess responsive information, not so much the documents, can probably meet that deadline, if that makes sense. Not so much maybe the documents, but if I need to amend or supplement the response, I think that's doable by me. So that's something I can work on starting tomorrow.
With all due respect, and not to have you actually out here on the record, but these have been pending since February. I think a response or a supplementation was long overdue, given how long these have been out there. And so I think 2 weeks.
Okay. Sure, that's fine.
All right. So, thank you all for reaching that agreement. What is it that you need my assistance on?
So what remains, Your Honor, from the original motion is the insurance matter from initial disclosures. There is a disagreement as to whether or not we just get the declaration page or a copy of the entire policy, including the amendments, riders, and any additions that may be there. That's where the disagreement is on that. I believe Mr. Pytel and I agree that I'm entitled to it. The question is, am I entitled to the entire policy, which I believe we are under the text of the rule 192.3F. I get a copy of not only the existence, but the contents. And so I believe that, Your Honor, in the word contents there, I get the entirety of the contents. There's no limitation to just the declaration page. And that would also address, Your Honor, request for production number 42, which is very much in the same vein as the initial disclosures in seeking a copy of the insurance agreements that would apply to this case.
All right. What's the dispute, Mr. Pytel?
Sean, I think the dispute is, the existence and the contents of the insurance policy, which the declaration page is going to have all the information that Mr. Hubbard is requesting. I know interrogatory 9, for example, is he's specifically asking for the policy number, the limits of the policy, the type of insurance, the entity who issued the policy. I mean, all that is information that's obtainable from a declarations page. Anything about an endorsement, amendment, riders, I don't think that's relevant because we are producing the contents and existence of the declaration page, which covers the information that he's seeking. Any endorsement about other Costco warehouse location, things like that, have no relevance to this warehouse specifically that's in Austin. So I think that's our biggest dispute there.
I do think 192.3F allows him to get the contents, and the contents of an insurance agreement should include any amendments and riders, etc. So I'm going to order the entire policy produced, including any amendments, riders, etc. Now, the rules make it clear that doesn't mean it's admissible, but
Correct, Your
I
Honor.
do believe it's discoverable.
Right. And I believe that would dispose of interrogatory number 9 and request for production number 42. So we are down to request for productions number 8 and 10. And Your Honor, if you'd like to pull these up, they are uploaded to Box, or I can share my screen, whatever is easier for the court.
Why don't you share your screen, because I'm having trouble getting into Box.
Your Honor, the sole issue on these two requests for production is simply the assertion of the attorney-client work product privilege. These two requests are requests for communication either with persons with knowledge who have been identified in disclosures or with third parties, excluding counsel. And so, Your Honor, I don't see how there is an attorney-client privilege or a work product privilege in communications with those third parties or with the parties who have been identified, certainly excluding any attorney-client privilege as to between Mr. Pytel and his client. And so, Your Honor, we'd ask that you overrule those assertions of privilege for these two requests.
All right. Mr. Pytel.
Yeah, I think, my kind of issue with these is that it's kind of overbroad about what they're asking for: communication logs or documents evidencing oral communications. I've already kind of communicated with Mr. Hubbard about what was collected for this accident. And, to the extent that something is privileged, I've already agreed to produce a privilege log. So I don't think the court should overrule privilege if I'm willing to, give a privilege log and document what may or may not be withheld. So, to the extent that they're asking about these communications, if there's any responsive documents that are not privileged, then it's my responsibility to produce those. But I think that goes along with a privilege log that I'm willing to provide to counsel. So,
all right. Well, it does make sense to me to wait until after you produce a privilege log and Mr. Hubbard determines whether he thinks based on what's in that privilege log that it is or is not something he wants to require in-camera production to a court or something like that. So, Mr. Hubbard, what would be the problem with doing it that way?
Well, the problem I have, Your Honor, is that by their own definition, these privileges don't apply once you disclose that information to a third party. If you look at the definition of work product in 192.5 or in the attorney-client privilege in Texas Rule of Evidence 503, that is talking about a very protected relationship that is not going to a third party other than, for example, the attorney and the client or the client's agent. Once you start talking to, for example, the police, even though the police weren't involved in this instance, that communication with the police is not privileged. And what we've worded in these requests is specifically designed to capture, for example, a communication with a responding officer. But
let's just look at number 8. And it includes, but isn't limited to, communications by, between, and among your employees. So the question is, if there are communications after y'all get notice of the claim, that arguably is subject to the attorney-client privilege or attorney work product, if it's for the purpose of getting professional legal advice. So it
and there
is
could be
limited to
something
third
there.
parties like police.
As to number 8, Your Honor, I can see the court's point. As to number 10, though, Your Honor, I think that is a different argument when you're talking about explicitly third parties who are not the client, because these are directed to Costco, or who's third party to Costco, excluding their counsel.
All right, tell me what your problem is with that, Mr. Patel.
well, I mean, I guess when he talks about a third party, I mean, that would also include, Costco uses third party administrators, adjusters, things like that. So I think that kind of falls into, these are things, anticipation of litigation, things like that. So I'm not sure, what type of communication he's trying to dig up or trying to find. He's talking about police officers. This is the base of the lawsuit is that an employee of Costco hit his client with a flatbed cart.
But if you're going to provide a privilege log, won't it say who the communications are by and between, and won't that allow him to more specifically hone in on what he wants that he thinks isn't privileged?
Right, and that's kind of what I was mentioning earlier, Your Honor. I think let me produce my privilege log. If he still has issues with that, then we can certainly take this up again at a subsequent hearing. But I don't want to say what I may not have or what I don't have until I have that information and I have the privilege log. Then we can certainly address that. So I stand on my objections to that.
All right, Mr. Hubbard, doesn't that make sense?
As to number 8, Your Honor, I can see where that makes sense. However, Your Honor, as to number 10, I don't see that making sense. Those insurance files are discoverable. There's case law that says I could go send a DWQ to his third-party adjuster, and we could go fight about the relevance, but that's not here today.
But doesn't it matter whether it's before or after you file suit or give notice of suit? I mean,
as to the insurance adjuster, it might. But as to, let's say, another customer who might have been in Costco that day, that doesn't.
Well, I agree with you. That shouldn't be protected. at all. But when you get the log, you're going to be able to tell whether it's, and it falls outside of what ought to be protected. So it seems to me that's something that makes sense to wait and see the log on. What else is it you need me to decide?
The next one, Your Honor, is request for production number 20. I'm going to try and do these to where I have to scroll as little as possible. 2021 and 23, I will have to scroll a little bit for 23. Your Honor, these are part of what I call the employment and training request for productions. In 20, we've asked for whatever training material Costco has provided to Mr. Cook, because one of the claims we have in this case is negligent hiring, training, supervision, and retention. And so we need to know, what did you give him? How did you train this individual? Was your training sufficient or was it negligent? And the only way I can do that are these requests for the training manuals, whatever you gave them. For in 21, if you look at that.
What is the equipment at issue?
It is a flatbed cart, Your Honor. They hit about ankle height when you're pushing them at Costco. They also have them similar carts at like Lowe's or Home Depot that you can stack kind of heavy product on.
Your Honor, it's not any type of special equipment. These are carts utilized by customers and employees there. I think the biggest issue I had is that he's asking about just any training material that this employee's ever had that may not even be relevant to operating a flatbed cart. And there's other requests that he specifically mentions, training for the equipment that was being used. I'm not sure that, anti-harassment training, any other type of HR training about operating the registers, how that's relevant to this claim or to his negligent, training, supervision, retention claims. Again, this involves an employee pushing a flatbed cart and hitting the plaintiff with it. So again, those are my objections to these training, and each one's a little bit different. And I think they're overbroad. So that's my objection.
And Your Honor, I'm caught in kind of a catch-22 where if I ask for specific training, maybe Costco does it, maybe it doesn't. I'm looking for that training to see what is and isn't there. I could ask for training on pushing this cart. Maybe they don't do anything specifically on this cart, but there's other training about situational awareness that he was provided. And so I need to be able to get that situational awareness. And that's why this is formulated in such the way it is that I can get all the training he's provided and sort through it myself.
I agree. It doesn't make any sense to me to withhold training materials. I assume there's a discrete body of training materials that is in writing or in video form or something that you could just hand over, and that way it's not the company deciding what might be relevant, but it's the plaintiff's counsel who gets to decide. There should have been something in here about X, Y, or Z, and it's not here. I don't see a way for you to do that without looking through everything that has to do with training. So, and I don't see the harm to the defendant on that. So I will overrule those objections. So that's on 20, 21, and 22.
2021, 23, and I believe 25 as well, Your Honor, just so you can see that.
And Your Honor, I mean, these are 23 and 25. These are separate. It's not all wrapped into just one question here. So 23, for example, it's all employee manuals, any tests, any memos, any evaluations, other written and videotaped materials that were given or completed by the employee involved in the incident for 6 months prior, including the day of the incident, and for 3 months after the incident. And then he goes on, not limited to, but any documentation distributed to any new employee training and any weekly, monthly, quarterly, yearly meetings attended by your employee. So, I mean, it sounds like, one, it's overbroad. He's asking for multiple time periods here. It's not just 6 months before. Now he's talking about, anything that's given monthly, quarterly, yearly. So I think this specific question, 23, is overbroad. It's a little bit different from what he's asking about training materials. This goes a little bit deeper. And I think it's a fishing expedition and involves things that aren't even relevant. And it would be burdensome on, my client to go ahead and dig up through the records and find out what he's looking for, because there is.
All right. I agree with you on 23. I think it's overbroad, and I think I would strike and other written and videotape materials that were given to or completed by your employee. So let's strike that language, but employment manuals, tests, memos, evaluations. Well,
Your Honor, this is really just more of the same.
I would say, let's limit it to employment manuals. I think tests, memos, evaluations, and other videotape materials. I think you got to get more specific about, you don't need memos about what food is being handed out to customers today as samples, or, there's going to be a lot of stuff. So let's limit 23 to employment manuals, but that, and 25, I think is acceptable as it is. So the only one that I think needs to be limited is 23, and limit it to employment manual. And then I would just say, once you take this employee's deposition, if you were to find out there were some other kinds of materials that you didn't specifically ask for that the employee identifies, then you can send another set of requests for production.
And that would be my intent, Your Honor.
Correct.
And I believe, just for clarity, on 25, that is granted and you're overruling the objection.
Correct.
All right. Just want to make sure my notes are accurate.
Yeah. So 20, 21, and 25, the objections are overruled. And 23 is the one I'm limiting just to employment manual. All right. Is there anything else?
Honor, I believe that addresses all of the items we have remaining. I will circulate an order to Mr. Pytel and we will submit it to the court.
Excellent. Thank you.
Thank you, Your Honor.
Y'all are excused. Y'all in just a minute. So, Mr. Hornsby, last time you appeared was December 2nd in this case, and the hearing was passed because on review of the return of service, the defendant had been served by posting on his door, but not by U.S. mail as required by the substituted service order. And you indicated that the mail had been sent, but there was no proof in the record. So you said you would reset once that proof had been filed. But in looking at this file, I see that, in fact, the case was filed in 2021.
That's correct.
So the attempt at service was in 2021?
There were multiple attempted services on this gentleman. Yes, 2021, 2024. We have attempted to serve him a bunch of times. The last time we attempted to serve him, he refused it.
All right. And where do I find that in the file?
We submitted to you, Your Honor, an updated affidavit, which showed that the service was attempted by USPS as well. And
Mine,
that was sent to you on 1/24/2025.
it wasn't filed.
It was our understanding that we were supposed to send it to you directly, Your Honor. So that's what we did. We did not
So
file it.
in order to get a default judgment, you're required to have filed proof of service, and the service, if there's substitute service, must be in the same form as the order granting the request for substituted service. And what I'm telling you is, there's no proof that substituted service was attempted. But in any event, we're now 4 years down the road, and service from 4 years ago at this point is kind of irrelevant. So you need to serve this guy again. You need to find him and serve him. And I see there's already been another defendant disposed of in the meantime, right?
Yes, that was his employer, and at the time of the crash, he was not in the course and scope of his employment. So on an MSJ, the employer was let out of the case.
So they must have found him to have been able to get that summary judgment motion.
Well, we know where he is, Your Honor.
Well, good. Then you need to serve him again.
Okay, yeah, we know where he is. That's not an issue.
All right. Well, you've got a motion for substitute service that tells you how to serve him, and so you need to do it according to the terms of the order, and do it again, and then you can reset in front of me.
Okay, thanks, Jess.
All
So
right.
see you later. Thank you.
All right, thanks. I saw when I reviewed the file in the Perez case, there was a controversy about what the settlement was going to say. Have y'all worked that out?
Yes, Your Honor. This is Brett Sanders for defendants Archer Western Construction LLC and Martin Tirado Mendoza. The settlement amount, the total settlement amount is confidential, Your Honor. And so the only thing that we're here today is to talk about the minor settlement and the amounts that are going to be going into a structured settlement amount for the minor settlement. So the judgment, the agreed judgment that we have sent to you, Judge, we've agreed that the total settlement amounts are going to be redacted. And so that redacted version omits or redacts out the total settlement amount and only references the amounts to be placed in the structure.
All right. So where do I find the settlement agreement that's unredacted?
If you want that settlement agreement, Mr. Luke Dow, the guardian ad litem, we've communicated today. If you're asking for that, he can send that to you. But again, Judge, that is a confidential document. So I would.
Yeah, but I'm not going to approve a settlement with a minor without knowing what everybody in the case got. I take it Mr. Dow knows what that is.
Yes, but
and he's not present today.
He should be. I just sent him a message, Your Honor, because I'm not sure why he's not on the meeting.
All right.
Oh, he just messaged me back and said he's in the waiting room.
Not for this hearing. He's not. You want to resend him the information? He must be in the wrong Zoom waiting room, because there's nobody in our Zoom waiting room.
Yes.
I think that Miss Williamson had a similar problem this morning. We've had all sorts of issues with our IT this morning, which I apologize for being late. That is why. So in the meantime, tell me who else is here.
Ryan Toomey for the plaintiff, Ashley Perez, and me.
Your Honor, Laura Sego for the defendants, Archer Western Construction LLC and Martin Tirado Mendoza.
There's Mr. Dow.
Sorry, Your Honor, I was in the wrong Zoom room.
Yeah, I think that happened to Miss Williamson as well this morning. So we're getting started late because first she couldn't get in and then I couldn't get into the pleadings file. So here, finally all together. All right. So I understand that this is a confidential overall settlement, and I'm going to want some information on that. We are currently broadcasting live on YouTube. If you all want to keep this confidential, then are you asking me to go off of YouTube?
Yes, Your Honor.
Yes, please.
All right. Then under the circumstances, since there's a minor involved,
versus
we will
GVA
go ahead
Pro.
and turn off.
Good morning, afternoon, Your Honor. Bo Cox and my colleague Joseph Simmons here for the plaintiffs, Overwatch GVA Solar.
Good afternoon, Your Honor. Scott Kessler here with my partner Todd Reed on behalf of the defendants GVA Pro and Alan Stalcup.
All right. I'm looking for Mr. Reed. There you are. Just make sure I know how to spell your last name. It's 2 E's. Got it. All right. I saw that there's also a motion to reconsider on file, and it seems like that might be related to this motion to compel. So let me just say, if it is, you really need to go back to the judge who I believe is Judge Mangrum, who ruled on the original motion to compel. Do y'all think this is related or not?
So thank you, Your Honor. So again, I represent the plaintiffs. We were the folks that prevailed on the relevant portions of Judge Mangrum's order. We're here on a motion to compel that was filed in March to get the documents that she ordered produced. They haven't been produced yet. The defendants filed that motion for reconsideration earlier this month. Our position, Your Honor, is that motion for reconsideration does not excuse the lack of production to date, and we are prepared and would certainly prefer to proceed at this point so that we can move on with the case.
Your Honor, without getting into the substance of the motion for reconsideration, it's directly related to the primary relief that Mr. Cox and his client are seeking this afternoon. The very documents that they're seeking to compel are the subject of the motion to reconsideration. We're seeking reconsideration of the judge's decision to force us to produce documents based on what we believe are misrepresentations as to what an underlying document shows, which caused the judge to order and compel the production of certain financial and trust documents. So if the motion for reconsideration, which is fully briefed and pending, is granted, right, if we're forced to compel those same documents, there would be a real conflict in judicial opinions between what the motion for reconsideration is seeking and what plaintiffs are seeking in this motion here.
And have you attempted to set the motion for reconsideration for hearing in front of Judge Mangrum?
The court has indicated that it will be submitted, it will be decided on the papers, and that a hearing would not be necessary.
And Your Honor, if I may just very briefly, Judge Mangrum's order was issued in November 2024. The defendants appealed that order to the Third Circuit via a petition for mandamus.
Yeah, I reviewed the file, so I saw that.
And so, our position is at this point they've exhausted their appellate relief, and merely filing a 7 months later motion for reconsideration does not excuse the noncompliance to date. That's our position, Your Honor.
All right, fair enough. Well, I will go ahead and hear y'all, and I will hold off ruling until I've talked to Judge Mangrum to make sure that our rulings are consistent and not inconsistent.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
Mm-hmm.
Oh, and we would like a record of this hearing.
Okay. And the last thing on our docket this afternoon is Pollson versus 504 Trinity.
Yes, Judge. Allison Tapp here on behalf of Mr. Pollson, the plaintiff.
Abby Sharpus on behalf of defendant Malavita LLC.
So have y'all attempted to reach an agreement on a docket control order?
We are agreed on it. Our understanding was it needed to be set just to get it to be signed, and we agreed.
So we have a rule on submission of agreed orders. It's actually a standing order. And if you all have agreed, then generally you don't need to have a hearing. So I'll commend you. Look at the website for the civil district courts in Travis County, and you'll find a link to documents, and among the documents are the local rules and also the standing order on submissions. If you'll take a look at that, you'll see how you need to do that for the future. But if y'all want to stick around this afternoon, you are my fifth case, and I'm happy to circle back around and well, let me just ask, have you uploaded the agreed order?
That was the issue. The filing was rejected. We were told by the clerks even agreed orders needed to be submitted to the docket. I don't know. I will defer to the local rule though, and I will resubmit it in that way, and maybe it will resolve the issue.
No, I mean, you don't need to do it for this. That's for future reference.
Okay.
I don't know that the clerk's office knows our local rules or knows about our standing orders. Some of the folks there do, but some of them are new. So I apologize for your getting the wrong information about that. But do take a look at the standing orders and the local rules, because we do things a bit differently here in Travis County.
Sure.
But have you uploaded to Box the agreed order?
We are attempting to do that now. I heard your earlier suggestion to the other attorney, so we're getting it uploaded for signature if that's possible.
So if you will go ahead and upload it to other materials, you represent the plaintiff, so you can do it under the plaintiff's other materials. If you've both already signed off on it, and I take it that you have, is that right, Miss is it?
Yes,
Sharafis?
it's correct. Yes, we have agreed to it.
Okay, then I'm happy to sign it. I didn't mean to suggest that you had to go through the submission process for this one, but I do want y'all to be aware that you don't need to set it for hearing next time.
Okay, thank you so much. We'll get it uploaded. If it's okay with you, Judge, I'll hang out here until we get it uploaded and just make sure it's there.
Sounds good.
Thank you.
Thank you.
Yes, Your Honor, let me apologize for my not being on when the hearing was noticed. I've recently changed firms. It's a little bit hectic. I apologize.
No problem. Glad you're here, Mr. Reeves. All right. Let me pull up this is the April 11th plaintiff's motion to modify docket control order and motion to compel depositions. Is that correct?
Yes, Your Honor.
And I take it y'all have attempted to work this out, but were unable to?
We have, and the problem has been with multiple parties. 3 of the 4 will be available. The 4th will not be. We reconstitute via email and phone calls, and then inevitably there's a health problem. Somebody gets called to trial in a city when they're on a 2-week docket, and we lose the depositions.
All right.
And,
so you're just
that's
looking. Go ahead.
And Judge, that's where we are. We do have an unrealistic trial setting of August 4. Ms. Gannon is relatively new to the case. She represents the inspectors. She and Mr. Dow and plaintiffs are in agreement for a reset to November 3. And the 3 of us, I think, have agreed to the staggered deadlines of a DCO with that November 3rd trial date. we need input from Mr. Reeves. And since we set this for hearing, we've gotten all of the parties' depositions scheduled, except for, if you will give me one moment, we need a deposition for the corporate rep, for the inspector, and we need a deposition date for Mr. Reeves' client. And the other issue is an issue that Mr. Dow has about where the plaintiff's depositions are taken. But I think we can make hopefully the most progress on the trial date, the DCO, and getting the final two-party deposition scheduled.
All right. So, Mr. Reeves,
Yes, Your Honor.
you
So this case is relatively old now, in our opinion. My client himself is a relatively minor, very minor, probably not even culpable party in this case. He's been sued. This is a house.
so you're breaking up,
situation.
so I'm missing some of your words.
I'm sorry. Can you hear me better?
For now.
Okay. Hopefully it stays that way. This is a house construction defect claim type thing. The entity that built the house is named Dantag LLC. That entity built it for the original owners of this property that then sold it to the plaintiffs. That entity has been defunct for a number of years. This house was built almost, I think, over 12 years ago. And they've also sued who was the principal of that entity when it was, when it was active and moving forward. My client is opposed to this because
I'm sorry. I missed who you said was the principal of the Dantag entity.
My client was.
Whose name is Luftak?
I'm not Luftak.
Okay.
Luftak, yes, ma'am.
All right.
We've offered up deposition dates twice, and to no one's real fault, they haven't occurred. And I'm in the process of we've gotten discovery to him. I'm in the process of filing no evidence motion, but my client is overall opposed to extending out more deadlines. So that's why he's asked me to do that, to say that to you. If the court were to do so, that's the court's decision. Obviously, I can make the trial date work if we're still in there at the time.
So November 3rd will be acceptable to you?
Yes, Your Honor.
And is your client available then?
Yes, I've confirmed that, Your Honor.
All right. And what is the reason why y'all need to postpone this?
From August to November, Judge?
Yes.
We are doing it to accommodate we could go to trial in August, but the fact of the matter is, because we've not been able to get depositions scheduled and completed, in fairness to the defendants, especially Ms. Gannon, who's relatively new to the case, I was trying to get along and be amenable. The reason I'm seeking help with the depositions is I don't want to face a motion for summary judgment when I haven't been able to take the parties' depositions through no fault. We've made over 25 requests by phone and by email to do this. I was licensed in 1989 when the lawyer's creed was adopted, and I'm not the kind of lawyer that just notices and forces a motion to quash. And I frankly don't think the other lawyers are either. But that is why we are where we are. And some direction from the court would be much appreciated.
All right. I understand. Okay. I am going to agree to the reset of the trial to
Your
November
Honor,
3rd.
I'm sorry, I don't mean to interrupt. My client's main concern really is that the amended docket control order, as it's been suggested for the court, it extends every deadline, including pleadings deadlines and things like that. And we think the pleading should be done. And, you know, I understand it's in discovery period given the extension of the trial date and things like that, but you know, he's added the late party that he was going to add, and we don't think there should be any changes to the pleadings. And so we would ask that date not be changed in the docket control order. If when the other ones we can probably be okay with.
Your Honor, the pleadings deadlines that the other three lawyers agreed to are in September, which is 2 months before trial and presumably a month after we complete depositions. I would like the opportunity to amend at least once after I get the parties' depositions taken.
All right. What about the other deadlines that have already closed?
The other deadline that is closed would be joinder.
Well, I see
our
also dispositive motion and mediation. Have y'all mediated yet?
No, Your Honor.
And the discovery period ended January 31st.
That was on the first DCO.
Yes. Is there another one?
Yes, Your Honor. With the second DCO, I can share my screen and show you what we've three of the lawyers have agreed to.
No. I thought you were suggesting there was a second one and you're seeking a third one. But the one I'm looking at from September 30th of 2024 is the only signed docket control order.
Correct, Your Honor.
Okay. Got it.
And that was before Dana and the inspectors were joined.
All right. And which ones are the inspectors?
Gormack and Harper. And Dana Gannon represents them.
So when were those new defendants added?
The last defendant was added in, I believe, November or December of 24. Dana, is that right by your calendar?
It is.
I see a first amended petition November 14th.
Yes, Your Honor.
And then
And if you're interested, Judge, the reason for that delay is there was an arbitration clause between the plaintiffs and the inspector. And for reasons we don't understand, but it doesn't matter, the inspector didn't pay their fee to the AAA, so they kicked us out. And within 30 days, we immediately brought them in suit. And we're happy to have all the parties together.
okay. All right. So the answer was filed back in December. So it's not like you just got added a month or so ago, right? The answer, you've been in the case since December 6th.
Yes, and for the last 4 or 5 months, we've all been exchanging dates, trying to get the depositions scheduled to no avail.
All right. So, all right. Well, I'm happy to reset the trial to November 3rd. And when I say reset the trial, I don't mean that I'm really the one who's resetting it. Those of you who've practiced here before know you all have to schedule dates yourself. That's not what the court does here. So you need to either contact the court administrator's office or go online to get dates for any hearings. So I'm authorizing you all to reset it to November 3rd, but y'all need to take the steps to do that. All right, and then the dates, Mr. Reeves, the ones that you're opposed to changing, tell me those again.
Really just the pleadings amendment deadline.
All right, well,
And anyone that would add other parties to, I guess if there's a joinder one, that one too, but overall, you know, it's been a long time and I don't think their claims are going to change at all. And even if they do, they should have to move for leave for that because, you know, my client's been in this since nearly the beginning.
all right, well, the amended pleadings deadline was May 12th, and what Mr. Lang tells me is that he's been trying to get depositions scheduled for several months, so since before that deadline. So I am inclined to go ahead and move that deadline. When are you seeking to move it to, Mr. Lang?
September 14 for plaintiff and September 24 for defendants.
All right.
And we uploaded the proposed DCO that Ms. Gannon and Mr. Dow were agreeable to. And from what I hear from Mr. Reeves, the only date there he objected to was the pleading deadline. That's Exhibit 2 of what we uploaded.
Okay, I'm looking for that now.
Your Honor, if you're inclined to, you know, grant them the extension, the date's fine. I'm not going to be that difficult about it.
All right. Well then, let me just, I don't see it under defendant Lutfax.
I didn't submit it. The plaintiffs did, Your Honor.
Okay.
Plaintiff's Exhibit 2.
Plaintiffs. I don't see anything in the plaintiff's file folder. I don't, Miss Williamson or Mr. Beck or Miss Fatima, do you all see anything filed in this box?
No, Judge, nothing.
Same here. All right.
May I drop it in the chat, Judge? Is there a chat? No.
No, there isn't a chat, but you can share your screen and let's look at it together.
Mr. Beck, you had mentioned emailing documents to you previously. Is it acceptable if I email that to you now?
Yes, you're welcome to reply all if you need to get something to me.
I'll do that right now. Thank you.
And
All
Judge,
right. So the language that says it's ordered, judged, and decreed that the case is hereby set for trial on the jury docket, that needs to go because I don't do that. That's not how we do in Travis County. So you can say it's ordered that the case may be reset. And it's not a 2-week period here in Travis County. It's just the week of November 3rd.
right. And we did check that with the clerk's office. That was an available date.
It is? Okay.
Yes.
I did not look, so I'll take your word for it. All right. So just change the language, or I guess we can strike it. If you're going to send it to us anyway. This isn't an agreed docket control order, though.
I'll remove the word agreed.
Yeah.
And then
you
I'll
can get rid of the word proposed as well. So just make it amended docket control order. And then
and then I'll remove the additional language that you mentioned at the bottom about
that the case may be reset on the jury docket for the week of November 3rd. And
It may be down by the signature block. The only other big one that could be missing is the certifications that are.
Yeah. Did you all, if you'll go on down to the bottom. Okay. Yeah, looks like it's there. All right. So if you'll just I will tell you that your dispositive motion filing deadline is about 6 weeks. No, it's 3 weeks before the trial. Right? The trial's November 3rd and your dispositive motion filing
Yes.
deadline is October
Yes, sir.
14th. So you would not be able to get any summary judgment motions heard if the filing deadline is October 14th and you have to wait 21 days. You won't get a hearing on your dispositive motions before
Thank you. You're right.
trial
You're-
setting. And I'll tell you that in Travis County, the week before a jury trial is a blackout week, so you can't set it a month before. And in fact, if you submit a proposed scheduling order to me, Mr. Beck has some language that I require to be dropped in that says if your dispositive motions are not heard at least 6 weeks before the jury trial setting, you may not get a ruling before the jury trial. So just FYI, my preference, and I think a lot of the judges here's preference, is that there be a hearing deadline for dispositive motions that's at least 6 weeks before the trial.
Judge, we will adjust that as you're directing.
Okay. And then I didn't see on the, if you'll go down to the trial setting date. So we also have changed our local rules here so that the docket call and the pretrial conference are not the first day of trial. So right now the docket call is, I think, 10 days before trial, and the pretrial conference is at the discretion of the judge who the case gets set in front of 10 days in advance. So what we suggest that you do is, instead of that November 3rd date for docket call and pretrial conference, is that you just put these will be scheduled by the court.
We'll make that adjustment.
Okay. All right. And otherwise that looks fine. You said there was an issue about where the deposition should be taken.
Yeah, that's my issue, Your Honor.
But one-
And
You can pull
Sample-
that down now so we can
Sure.
see each other better.
But before that, Judge, the only other issue, I think we're all cooperating better now, but I don't want to have to run and file a motion for continuance if I get a summary judgment motion. I'd like for the court to please rule that I get to take the parties' depositions before I have to face a motion for summary judgment. That's all.
Okay. That sounds reasonable to me.
Thank you,
Anybody
Judge.
disagree with that?
that's fine. The last open issue, Your Honor, is the and I represent the sellers of the home, and the plaintiffs have now moved to New York City, and I want to physically be in New York to depose the plaintiffs on our dime. And there was an objection to that. As the court is aware, Rule 199.2 of the Rules of Civil Procedure, B2, provides that the parties may be deposed in the county where they reside, or where they're employed or regularly transact business, or the county of suit. And my preference, and the preference of my clients, because my clients are being sued for north of $1 million in this lawsuit, is that they want me to physically be in the same room when I depose the plaintiffs. Plaintiff Sosner is Associate General Counsel at McKinsey in New York City. Her husband also has a significant professional career, and there's no undue prejudice to the plaintiffs who live in New York to physically be deposed in the city where they reside, Your Honor. So we, for whatever reason, we could not reach an agreement to allow me to physically appear. I told all the other lawyers that they don't need to be in New York if they choose not to be. Rule 199.5 A2 provides that they don't need to be in New York. My clients now live in California, and I've made my clients available either to be deposed in person or by Zoom. The lawyers chose to depose my clients by Zoom, but they were certainly amenable to come out to Northern California and take their depositions. So my request, Your Honor, is that I be permitted to depose Plaintiff Sosner and Plaintiff Cross in person in New York. The parties have already agreed upon a deposition date, and that's really sort of the issue. And some papers were filed by the plaintiffs saying that this was sort of a cost issue, and that it would add $3,000 of expenses. But, you know, in the grand scheme of things, given the fact that the lawyers can be in San Antonio and Houston, there's no additional cost. I'm not asking the court to award me costs for my travel time, and I'm setting up the deposition, Your Honor, which is going to be at my client's cost as well. So I don't understand what the issue is here. We have depositions all the time where some people are in person, some people are remote, and it's our preference, given that we're the defendant in this suit and we're sued by the plaintiffs who have now moved to New York, that I be permitted to fly to New York and to take their deposition in person.
All right. So who is opposing this?
We are, Your Honor, plaintiff's counsel. And the reason is we prefer not to spend $3,000 a day in travel and an overnight stay to sit with our clients during the deposition. The husband is not a lawyer, has never practiced law, is not a litigator, and is not comfortable with the process, and I don't blame him. Ms. Sosner is a lawyer. She's a transactional corporate and IT lawyer, not a litigator, not an arbitrator, not at all comfortable with the process. And they have just returned from California with a 3-week-old baby born through IVF, through a surrogate, and exposing them to the process of going to the conference room, being around. I mean, they can wear a mask, there's no doubt. But if anything good came from the pandemic, it was the ability to use Zoom. And I hope to God never to have to travel for a deposition again as long as I live. Fact of the matter is, my associate Haley Nichols will go to New York and sit with our clients if the court is so inclined. And the only other point I want to make is, if the rules are such that Mr. Dow is absolutely entitled to it, we're not going to ask the court to rule against the rules of procedure. It's just as a practical matter, we were trying to save the money, save the exposure, and save the time. But we will live with whatever the court decides to rule.
All right. Does anybody else want to be heard on this issue?
If I could just respond very briefly, Your Honor.
Sure.
This is not a situation where my clients are the plaintiffs. They're the ones being sued. If the plaintiffs wanted to come to Travis County and be deposed, which the rule contemplates, they could certainly do that. But the cost is, in the grand scheme of things, minimal, given the amount in controversy, the multiple depositions that are going to take place, the fact that there's two of the plaintiff's lawyers on this hearing. If this was really an issue, there would be one lawyer. And there's the rules contemplate that I'm entitled to depose them in person, and that's, in terms of just fairness of being able to take their deposition. It's a lot different, as the court is well aware, of taking a deposition in person versus Zoom. And it's no cost, because the rule contemplates that the defendant, the plaintiff's lawyers, could be in San Antonio.
All right. Well, generally, I agree that if everybody agrees to take a deposition by Zoom, that can be an effective way to do it. But if the person who wants to take the deposition, who's a defendant, who wants to depose the plaintiffs, wants to do it in person, then I think, then Mr. Lang, it's up to your clients as to where they want to be deposed, whether it's in New York City or in Austin. So once they make that decision, the rest of the lawyers are welcome to appear by Zoom, but I think it's a fair request by a defendant to ask to depose the plaintiffs in person. There are certain advantages of in-person depositions. I agree they're a lot fewer than they used to be, but I will honor a request by somebody who wants to take a deposition in person. All right.
Two things before we're excused, if I may, Judge.
Yes.
Very briefly. When Mrs. Nichols and I appear together on something like this, we each bill half time. We're not socking the clients with 2 hours of lawyer time. And my stepsister, Courtney Dibble, says hello.
All right. I'll tell Courtney I said hi. If you all can just make the changes in the order to reflect all of this. I don't know if you need to include in the order that the defendants can depose the plaintiffs in person, but the plaintiffs get to choose where.
I submitted an order previously, Your Honor.
Okay. And where is that?
I believe it was attached to the response to the request for Zoom depositions.
Okay. So you filed it.
Yes.
Okay. All right. We'll take a look for it. And if we don't find it, we'll let you know. Otherwise,
in the process of circulating orders via email, if you'll just reply all to that email as well with that.
Send it again. Yeah.
And we'll approve the form of it. We're not going to drag it out.
All right. So if we dealt with everything we need to.
Thank you very much, Judge.
All right. Thank y'all.
Thank you, Your Honor.
Y'all are excused. All right. And you all wanted a record. So Miss Williamson's going to make a record. Let me give you a couple of statements about that. Miss Williamson is certified to 225 words a minute. That's a lot, but if you get going, all of us can go faster than that. And I'll just advise you also that it's difficult if two people are speaking at once, because on Zoom, our voices cut in and out when that happens. So Miss Williamson has a nonverbal cue she will send you if either you're going too fast or two people are speaking once, and she will shake her head no. Shaking her head no does not mean she disagrees with what you're saying, but she's not able to make a record for one of those two reasons, or sometimes both. Especially if you're reading something. Reading things always makes people speed up. So I'll just alert you to keep an eye on her. All right, and y'all have 30 minutes. That's 15 minutes aside. Mr. Beck will keep track of the time. And let me pull up your case. That I have taken a little while to review your file, so I'm somewhat familiar with it. All right, so it's plaintiff's motion.
Yes, Your Honor. May I begin?
You may.
Well, thank you, Your Honor. Again, my name is Bo Cox. I'm with Fulbright. I represent Overwatch, GVA, Solar, MFLP. With my 15 minutes, I'd like to reserve at least a couple of those minutes for rebuttal, and I'll try to keep an eye on the clock. Your Honor, may I share the PowerPoint that I've uploaded in the box and also provided to counsel?
You may.
Are you able to see that, Your Honor?
Not yet.
Okay. How about now, Your Honor?
Yes.
Perfect. Hopefully this will help us cruise through the issues relatively quickly. Your Honor, this is our second motion to compel. I will just very briefly touch on the factual background because I think it's important to know what the case is about when we're talking about the documents that we're looking for, among other things. As part of the overview, I would note that the defendant's response, which was filed yesterday, did narrow some of the disputes, which we're appreciative of. That having been said, a primary point of dispute, as you're already aware, is that our position is that certain trust-related materials that were ordered to be produced by Judge Mangrum back in November still have not been produced. We believe in violation of that order. In addition, Your Honor, while we now have a representation from the defendants about when they will produce the other types of documents that have not been produced, we do not have an agreement on when deponents are going to be made available. And then very briefly, lastly, Your Honor, I'll talk about our request for a small amount of fees in this instance. So as Your Honor is probably already aware, this is a commercial real estate dispute. My client, Overwatch, invested $7 million into an apartment complex deal that is called the Solara project. It was the majority owner of the Class B shares. It had the vast majority of the equity in the project. The defendants are GVA Pro LLC and its CEO, Alan Stalkup. They were the sponsor of that commercial real estate opportunity. The project itself was located in San Antonio. It was a $35 million purchase price, and it was to be financed with a $30.1 million loan. From our perspective, and our allegation in this case, is that the defendants could not increase that loan amount or otherwise modify the financing arrangement without, according to the agreement we signed, the prior approval of a majority interest of the Class B members, which is just my client, Overwatch. Rather than procure a single standalone $30.1 million loan for Solara, it appears that what happened is GVA went and got a different size loan, a $56.3 million loan, and used that much larger debt instrument to purchase two apartment complexes. One called Solara, in which my client invested, the other called Haverwood, in which my client did not invest. That was owned by Alan Stalkup and friends. The problem, from our perspective, is that when he got that larger loan, he cross-collateralized our property, Solara, with his property, Haverwood, thereby tying their fates together. Ultimately, Haverwood, the other project that my client was not invested in, was a non-performing asset. The defendants eventually abandoned that asset, and in March 2024, the lender foreclosed on both Haverwood and my client's property, Solara. Thus, my client's entire $7 million investment was wiped out. Your Honor, this was not by any stretch of the imagination the only foreclosures or financial difficulties that Mr. Stalkup and GVA were having. It has been widely reported in the press, including in The Real Deal, which these are screenshots from, that Mr. Stalkup and GVA's empire is effectively crumbling. He's been sued over his personal debt, his personal jet. He's defaulted on debts that top over $600 million. And relatively recently, he was sued in New York by another lender who alleges that Mr. Stalkup committed, quote, bad boy acts in violation of the $350 million loan agreement. That lender alleges that GVA transferred property interests unlawfully, committed forgery and fraud that would make even brazen criminals blush. Suffice to say that in the 2022-2023 timeframe, GVA was experiencing a substantial amount of problems. After we filed the lawsuit, we got in touch with a former GVA employee named Zach Richards, who produced, pursuant to a subpoena, documents that show, from our perspective, that around the exact same time that Mr. Stalkup and GVA are having all of these problems, that Mr. Stalkup and GVA transferred up to $100 million into trusts that we believe are called the Fernald Point Trusts. Now, we then amended our petition.
I'm sorry.
No problem. They're called the Fernald Point Trusts.
Will you spell that for the court reporter and me?
Absolutely. It's FERNALD. You can also see it right here in request for production number 55, Fernald Point.
Got it. Thank you.
No problem. So we amended our petition to add claims for, among other things, fraudulent transfers, which of course, as Your Honor appreciates, is a standalone cause of action, right? We have to prove the elements of a fraudulent transfer at trial. And we asked the defendants to produce, almost a year ago now, basic documents and information related to the creation of these trusts that we've learned about and related to the transfers that have been made into those trusts. Defendants refused to do so. And that's what led to the first motion to compel, the one that Judge Mangrum heard. That was heard in November 2024. Just so you have a sense of what the requests are, these are not burdensome by any means. It's a request of any trust document that was entered during the relevant time period, a copy of any trust agreement that contains Fernald Point, and documents sufficient to identify transfers into those trusts. It's also just one interrogatory. It's tell us the identity of the trustee, the identity of the beneficiary, and the date on which the trust was established. This is all very basic, non-burdensome information that we need to be able to prove up our claims for fraudulent transfer against Mr. Stalkup and GVA. We presented fulsome argument, Your Honor, in November to Judge Mangrum. It was a lengthy in-person hearing in Austin. She entered an order dated November 26 that granted us the production of these documents and the answers to this interrogatory. The order is in your file as Exhibit 7, but it's of course on the docket as well. Now, what happened next? What happened next is that the deadline to produce these materials was December 6th. And on December 2nd, the defendants filed a petition for writ of mandamus and an emergency motion for stay in the Third Circuit. We don't begrudge them for that, Your Honor. That is their right to seek appellate relief of Judge Mangrum's ruling. On December 4th, 2 days before the compliance deadline, the Third Circuit stayed all proceedings in the trial court so that it could have had time to look over the petition for writ of mandamus. On January 23rd, the Third Circuit denies the petition and dissolved the stay, meaning that now there's nothing precluding compliance with the prior order. Rather than produce the documents on February 7, the defendants appealed to the Supreme Court of Texas, and the Supreme Court eventually denied their petition as well. At no point has any stay been in place since January 23rd that would have in any way excused compliance. Now, I do want to be clear, the delay is prejudicial to us, right? We've been seeking this information for almost a year. We need the documents to prove up the elements of our claims, and we need the documents to take effective depositions. I don't want to depose all these witnesses once and then come back and have to do it again if and when I ever get these trust-related documents. That's not remotely efficient. And of course, from our perspective, GVA's financial problems pose insolvency risk. We've got a lawsuit up in New York that's talking about hundreds of millions of dollars. We want to be first in line. Frankly, Your Honor, at this point, there is no excuse for the continued failure to comply with the court order. I have a sense that you'll hear from opposing counsel that the filing of the motion for reconsideration is somehow an excuse. We respectfully disagree with their position in that regard. This motion for reconsideration was filed 6 months after the prior discovery order, 4 months after the Third Circuit dissolved the stay, 2 months after this motion to compel we're here on today was filed, and 1 month after the Texas Supreme Court denied the petition. To be super clear, there was nothing in Texas law that would indicate or suggest that a motion for reconsideration filed long after, months after the compliance deadline with a court order somehow creates another automatic stay. That's just not how this process works. So you'll hear this at the end, Your Honor, but our request is that you simply conclude that they should have produced these materials and order them to produce them. There's a second topic that I said that I would hit upon.
And just to be clear, your allegation is that those should have been produced January 23rd or shortly thereafter.
Yes, Your Honor. Technically, I think it's January 25th because there were 2 days left on the 10-day compliance period from the prior order, and we're now obviously 5-6 months past that.
Okay.
Your Honor, the second topic that luckily we now have narrowed is that thus far in this case, the document production related to the cross-collateralization, related to just kind of the underlying issues in the case, has been insufficient. At this point, the good news is that yesterday, though, in the response that we received, the defendants have now agreed to produce by June 27 the balance of the documents that they have not yet searched for. To be clear, what that means is this. So far, the defendants have produced 365 emails, every one of which includes Alan Stockett. We have said, hey, that indicates to us that you've only collected from Alan Stockett. They have not confirmed one way or the other what the answer is to that. But they're now saying that they will go back and they will search for documents that other custodians have. Benoit Richard, Blake Davis, Drew Nelson, and we take them at their word in that regard. But we do ask that your honor memorialize that agreement that they made in their response in the order on this motion to compel. We want that to be a court-ordered deadline of June 27, given that this has taken so long. Now, the next issue, Your Honor, and I'm trying to be mindful of my time, I think I've only got about 4 minutes, is defendant's proposal on depositions. We've been seeking depositions in this case for ages. We've been seeking them since late 2024. As Your Honor may have seen, Judge Mangrum ordered the defendants to make 4 specific witnesses available, but those depositions got derailed when the Third Circuit issued its stay. Since the Third Circuit issued its stay, we have continued to attempt to work with the defendants to schedule those depositions. Now, I do want to point something out to Your Honor. In the response that was filed yesterday, it's just 1 paragraph on depositions. They indicate, quote, "It is worth noting that plaintiff has not requested a single deposition since November of 2024. That's their words. Plaintiff has not requested a single deposition since November 2024. They say, nonetheless, though, we'll make these witnesses available by September 30th. I've got 2 problems with that, Your Honor. The first is that we have repeatedly asked for these depositions. I mean, repeatedly. I heard what the lawyer in the prior hearing said about not liking to just notice stuff up and invite motions to quell. That's not my style either. But I will show you, Your Honor, that as early as January 27th, this is less than a week after the original stay was dissolved, I wrote to them and I said, guys, now that the Court of Appeals has ruled, I want to get on with the case. I said, we'd like completion of GVA's document productions, and we would demand rescheduling of GVA's witnesses. It even says the names of the witnesses. These are the same folks that Judge Mangrum had previously told the defendants to make available. So when, Your Honor, in the first sentence here, they say it's worth noting that plaintiff has not requested a single deposition since November, I just want us all to understand that that's not true. I also followed up, Your Honor, on February 7th because I hadn't heard anything back. And I said, hey, guys, we're going to need to start working on a motion to compel responsive emails and communications, trust-related materials that were previously ordered, and renewed deposition dates. Again, Your Honor, crickets in response. So at this point, Your Honor, what I would ask is that when you enter your order on the motion to compel, you decline the defendant's proposal to somehow put these depositions off for yet another 125 days. There is just absolutely no reason to do that. We are eager to get on with this case. I would ask that you have them put these witnesses up within 60 days, which is the exact same amount of time that Judge Mangrum gave back in November. And assuming they comply with your order to produce the balance of their documents by June 27, that gives us 30 days to take those depots, and I'll make it work. Your Honor, last piece of this, and then I'll stop so I can reserve a minute or two, is attorney's fees. I have almost never asked for attorney's fees in motions to compel. I'm not asking for a lot in attorney's fees here. We're seeking $7,500, which is an objectively reasonable amount. We're seeking those fees through Rule 215.2B8, which provides that an award of fees is mandatory when a party violates a discovery order unless the failure was substantially justified. We supported that with an affidavit from my colleague, Mr. Simmons. And frankly, Your Honor, at this point, we would like the award to deter future violations of future orders. Your Honor, with that, I'll cede and just reserve a couple of minutes for rebuttal.
All right, thank you.
Thank you, Your Honor. I'm sorry, my computer just glitched for a second. Can you hear me?
I can.
Good. It just flashed, so I wasn't sure what happened. Scott Kessler from Ackerman for the defendants, along with my colleague Todd Reed. First, Your Honor, as you stated at the beginning of this hearing, we have filed a motion for reconsideration. The motion for reconsideration is not based on the same arguments that were made in the appeal to the Court of Appeals or the mandamus to the Supreme Court. It's on a different basis. And that basis, right, is based on the information that plaintiffs used at the hearing on the first motion to compel, where they showed a spreadsheet that had been produced by Mr. Richards. And they indicated that that spreadsheet had showed a series of transactions showing millions of dollars going from defendant entities into trusts owned and controlled by Mr. Stalcup. Now, that is inaccurate and a misrepresentation of what that document shows. There is not one transfer on that document that counsel showed before that indicates any transfers have been made to any trust. And the individual who created that document and produced that document has not substantiated or supported the line entries in that document with any admissible evidence. That is the same individual, by the way, who's no longer an employee of GVA. He's also the same individual in that New York complaint who we believe, to the extent there was any forgery committed based on the allegations by the plaintiff in New York, he is a rogue employee who was involved in that forgery. The forgery, at least the allegations of forgery, had no involvement by Mr. Stalcup. He had no knowledge of it. It was, again, this rogue former employee who's the whole basis for the trust documents that plaintiffs are seeking through this motion. Now, I don't want to argue the motion for reconsideration before Your Honor, because I know that's procedurally improper and it's not your motion to hear. But as we set forth in that motion, we go through all the transactions listed on that document and explain actually what they are. There's only one transfer that goes to a trust. That trust is not a trust that's owned by Mr. Stalcup, that's related to Mr. Stalcup, or any of the defendants in this action. Rather, it's a distribution that's being made to a
So
GVA.
let me just stop you and say, I'm not going to hear the issues relating to the motion for reconsideration. That is for Judge Mangrum to decide, and I take it that you included this in your motion.
So thank you, Your Honor, and I understand and appreciate that, and I will stop, but I will just say this. The grounds for the motion for reconsideration are separate and apart from the arguments that were made in opposition to the prior motion to compel and that were made on appeal and on mandamus to the Court of Appeals and the Supreme Court. And we believe that those issues need to be heard and determined by Judge Mangrum first before this motion to compel. And we've stated...
that is my intent, is to let her do that before I rule.
And we stated in our response that if we lose that motion, we will produce those trust documents within 7 days. If we win, then there's no documents to produce. But as Your Honor knows, that if we were to produce the documents pursuant to an order on this motion, and then we win the motion for reconsideration, the horse is already out of the cart, and there's no way to put it back in. And so we would ask that the motion for reconsideration be determined first, and then we can take it from there. We either produce the documents or we have no obligation to do so. And that entirely obviates the whole need for the present motion. It's really spurred by the trust documents, which is a reason why attorney's fees should not be awarded, because our position is completely justified by the motion for reconsideration. With respect to the other documents, we have said in our response that we will produce those documents by June 27th. Plaintiff has taken us up on that offer, so we don't believe that's an issue in dispute. With respect to the depositions, there's one email that you were shown asking for 4 depositions back in January, right? And that was before we filed our motion for a stay and mandamus to the Supreme Court of Texas. So in essence, that motion was soon filed after Mr. Cox's email, and we were waiting for a determination. We have then filed the motion for reconsideration. There are going to be a whole host of documents that Mr. Cox will be receiving within the next 30 days. We believe that 30 days to conduct the 4 depositions and to give Mr. Cox time to prepare for the depositions and any other discovery issues that arise, it's only fair to say, let's give the parties a little bit more time to conduct these depositions. There is absolutely no rush. There's no urgency in this case. We don't even have a trial date set in this case. So there's no reason not to say, let's give the parties time to take depositions so they can be prepared for those depositions, so depositions don't need to be retaken or continued. Plus, we're dealing with the summer months. People's schedules, vacations, other personal issues will arise to think that maybe 30 days after we produce our supplemental documents and 30 days to complete all these depositions may not be enough time. So we offered to schedule depositions within the next week for depositions to be completed before the end of September, which we think is a fair result. Mr. Cox alluded to the New York litigation to say, hey, there's all this urgency because there's hundreds of millions of dollars that are at stake in New York. Number one, we deny all the allegations in the New York action. Second, I'm counsel in the New York action, so I have the liberty of knowing that we had our first conference before the court in the New York case this morning. According to the schedule set forth by the judge in New York, fact discovery is not even going to close until more than a year from now, with expert discovery and dispositive motion practice going on through the summer of 2026. So there is no concern about there being a judgment levied against Mr. Stalcup to the extent there's any liability, which I state again, we deny. But there's no fear or concern about a judgment in that case until most likely the end of 2026, if not 2027. Unless Your Honor has any further questions, I rest.
All right, thank you.
Your Honor, may I just use a couple minutes of rebuttal?
You may.
Your Honor, I think what I sort of take away from that presentation is that the defendants are doing what I sometimes do when I represent defendants. It's let's kick the can as far down the road as we can. We've already had months of delay that were a result of 2 different failed appeals by the defendants. We're now here ready to get started, begging to get going. Your Honor, on the trust documents, I would just respectfully submit that counsel, neither through its briefing or its argument, has shown you any case anywhere from any Texas court that says that filing a motion for reconsideration after the compliance date somehow excuses noncompliance or justifies some sort of automatic, ephemeral, everlasting stay. Your Honor, secondarily, with respect to the other documents that are now going to get, I heard counsel say we're going to get a host of documents. We appreciate that. These documents were requested a year ago. And so we would ask, Your Honor, that you include in your order an order ordering them to produce these materials by June 27th, as they have promised. Your Honor, similarly, with respect to the depositions, I do take issue with the notion that we haven't been actively pursuing these. We asked for them in January as soon as the stay was dissolved. We followed up. I showed you the email in February to ask for the depositions again. And this is important. We filed this motion to compel in March, asking for these depositions, asking for these documents. If the defendants wanted to at any time before yesterday, they could have said, hey, we'll get this stuff to you in a month, or we'll make these folks available. Instead, they're now putting us in a position where we're not going to get basic depositions until the end of September. I would respectfully submit that there's no basis for that. I would ask that you grant our motion in full, Your Honor.
All right. Have you submitted a proposed order?
Yes, Your Honor, we have. It should be in box. My associate Joseph can correct me if that's incorrect.
I have it ready to upload, but I haven't uploaded it. I can upload it now if that would be convenient.
Mr. Beck, would you prefer to have him email it or upload it?
Since it may be a minute before we sign it, I would prefer email, Judge.
I can do that now.
All right. And Mr. Kessler, why don't you go ahead and send us your proposed order as well?
Yes, Your Honor.
All right. And I will confer with Judge Mangrum to find out what her schedule is for dealing with the motion for reconsideration. And we will take it from there.
Thank you, Your Honor. We appreciate your
All
time.
right. And you said the PowerPoint is in box?
Yes, Your Honor. Correct, Joseph? I'm technologically incompetent. Okay, perfect.
All right. Well, thank y'all. Y'all are excused.
Thank you, Your Honor.